Hello, my name is Mark Coen, and together with my colleague Niamh Howlin, I'm going to discuss some of the findings of an empirical research project we conducted, in which we interviewed 22 judges about their experience of presiding over jury trials in Ireland. It's a wide-ranging study, but for the purposes of this paper, we're going to focus on some of the findings relating to jury misconduct. It's fair to say that internationally, the issue of jury misconduct has attracted increasing levels of scrutiny from judges, politicians, and academics over the past 20 or 25 years. The rise of the internet has been a key factor in this. In our study, we looked at three aspects of jury misconduct: the warnings judges give to jurors about misconduct, their views on the punishment of errant jurors, and the question of statutory reform in this area. One question that we're asking is whether this area of jury misconduct is yet another example of Hibernian exceptionalism, the idea that Ireland is often an outlier in relation to international criminal justice trends. The full citation for the report of our study is provided at the bottom of the slide. Our co-authors are Colette Barry of Sheffield Hallam University and John Lynch of University College Dublin. In part one, I'm going to provide a brief sketch of the law relating to jury misconduct in Ireland. First, the question of misconduct warnings. And in Ireland, the only warning relating to misconduct we discovered in the course of our research is an internet warning. And as Niamh will go on to show, not all judges give this warning. So in relation to the internet warning, the first recorded example of an internet warning being given is in a newspaper report from 2008. I've reproduced the headline on the slide. In Byrne in 2010, Mr. Justice Charlton, his picture is on the right there, referred to an emerging practice of judges warning jurors in relation to the internet. However, unlike in other jurisdictions, for example, England and Wales, the giving of the warning is not mandatory in Ireland, and the Court of Appeal has made this clear in the case of McCarthy. More recently, in Sheehan, the Court of Appeal has observed it is now common for judges to advise jurors not to engage in internet research, but it is not compulsory for them to do so. There have been few documented instances of jury misconduct in Ireland. 2017 was a bit of a flashpoint. Two cases collapsed within 2 weeks of each other because jurors went on the internet. Also, a High Court judge who was retiring gave a retirement interview in which he identified the internet as a major problem in jury trials. The most prominent example of jury misconduct in appellate case law is that in Hegarty, a Court of Criminal Appeal decision of 2013. In that case, a juror informed a jury minder that she had gone online to research the specifications of a van that was a locus in a sexual offences case. She'd looked up specifications relating to the internal layout of the van, which was an issue in the defence case. Now, the judge in that case discharged that particular juror. The accused or the convicted man, Hegarty, appealed on the basis that the entire jury should have been discharged, but the Court of Criminal Appeal said no, the discharge of that one juror was sufficient on the basis that the judge was entitled to accept her statement that she had not shared the fruits of her research with other jurors. No Irish juror has been punished for engaging in jury misbehaviour. Again, unlike other jurisdictions in England and Wales, prior to the enactment of the statutory offence of jury misconduct in 2015, judges there had made quite fiery comments in relation to misbehaving jurors and jailed a number of them. But in Hegarty, the van case, that particular juror who undertook the research was described as conscientious in reporting that she had done this to the jury minder. It's unclear in Hegarty if a warning in relation to the internet was given in that case. Finally, in relation to statutory reform, many jurisdictions across the globe, in Australia, New Zealand, England and Wales, have enacted statutory offences of jury misconduct. We have not done this in Ireland. It was recommended that this should be done in 2013 by the Law Reform Commission, but so far this recommendation has not been acted upon. That's a whistle-stop tour of the law, and you can see there are quite a few differences between the Irish position and that in other jurisdictions. And I'll hand over to Niamh now to talk about some of the findings from the interviews. Thank you.
Hello, I'm Niamh Howlin, and I'm going to talk in a bit more detail about some of the findings from our study. Because of time constraints, I won't go into much detail about our methodology, but we can discuss that in the live session afterwards. We interviewed 22 judges, and the judges addressed three main issues in relation to jury misconduct. First, warning jurors not to do it. Secondly, punishing them if they do it. And thirdly, statutory reform. So I'm going to look at each of these in turn. As for warning jurors, about half of the judges we interviewed said that they always instruct jurors not to conduct online research. And they gave various reasons for this, including the ubiquity of smartphones. One said, 90% of people have smartphones now, have access to the internet. They all can do it automatically. And there's a temptation to do it automatically unless you specifically warn them not to do it. About a third of the judges said that they would only sometimes give an internet warning. And this depended very much on the particular case or whether, for example, they thought that there might be some online material relevant to the case. Surprisingly, 5 of the judges said that they did not refer to the internet at all and gave no warning. They seemed, some of them, to be of the view that, in the words of one judge, mentioning the internet and the rest of it is only putting ideas in people's heads. In other words, it was better not to mention the internet at all, lest jurors be given ideas. We asked those judges who did give warnings to tell us a bit more about the nature of the warnings that they gave. Again, we found that there was quite a variation in the responses. Some judges preferred to list examples of specific websites or social media platforms, whereas others couched their warnings in more general terms. One said to us, when you tell a jury something and you list all the various Google, LinkedIn, etc., they seem to understand that. You see them nodding, and they seem to get the picture, but it's better to tell them too much rather than too little. By contrast, another judge said, I probably don't know the half of the ones that are out there. I know the Facebooks and the Snapchats. I know of them rather than anything about them, but I'd say the internet. It's one thing to warn a jury not to engage in internet searches, but it's quite another to deal with the reality of them having done so. As Mark illustrated, Irish judges are quite reluctant to exercise their contempt of court jurisdiction. Most judges told us that they didn't warn jurors about the possibility of being punished for violating judicial instructions, and some of them were very uncomfortable about this. As one judge said, why should you have to warn them about the fact that they might be in contempt or committing an offence? You have no reason to suppose that they won't do the right thing and that they're not decent, honourable people. And another, I think you would need to be seeing very obvious signs of the jury going AWOL before you do anything like that. Only one judge told us that they referred to contempt of court as a matter of routine in all cases. We also asked the judges if they had ever considered jailing jurors for misconduct or if they would consider doing so in the future. Most of them regarded this as a very extreme step. As one said, you'd be loath to jail a juror if you felt there was no malafides in their activities. About half of the judges said that this could never be countenanced, but the other half refused to rule it out in extreme situations. Finally, I want to mention the issue of statutory reform. As Mark has outlined, the Law Reform Commission has recommended the introduction of a statutory offence of jury misconduct. The judges were very divided on this recommendation. 11 were opposed, 9 were in favour, and 2 gave us no view either way. Those who opposed the proposal gave various reasons, including that the common law offences were sufficient, that a new offence might deter people from undertaking jury duty, and that it would be very difficult to prove the elements of such an offence. Those who agreed with the recommendation generally did so on the basis of 2 reasons. First, in the words of one judge, it obviates the need for the trial judge to be the bad guy. And secondly, that the law on misconduct would be clarified and would be easier to explain to jurors. Of all the topics discussed in our interviews, misconduct was probably the one that attracted the most varied responses. Several judges told us that they were grappling with how best to direct the jury in relation to online misconduct, and one said that the judiciary was on something of a learning curve in this area. Thank you.